sit somewhere. Where? Is he running?
We agreed at 11.
Yes.
Well, I assume quorum is just the same.
You're not considering the immense public interest in this matter. I've been joined by colleagues from the LSK.
Okay.
Yes. There
So
is
we
Mr. Kamau.
Okay, let me repeat the quorum now. We start with the first applicant.
Yes. Abuya.
Mr. Abuya.
Wanjir.
Wanjir.
Kamau.
Kamau.
Dinambo.
Dinambo.
And Kamau.
Two Kamaus.
Yes.
So we need to give another Kamau.
And Mr. Wanga.
Kamau who?
This Kamango.
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 Oh, Kamango. Abuya. You're saying Kamau, Kamau. Kamango.
Kamango, and then there is a Mr. Wanga here.
Mr. Wanga.
Yes.
This one's for the first applicant.
Yes. First and
First
second.
and second.
Yes.
Then Ms. Sang. Ms. Sang leading Mr. Smith and Mr. Ismail for the first respondent. We have Mr. The name?
Mr. Rotich.
Mr. Rotich.
Alongside Mr. Callisto for the second, third, and fourth respondents.
Mr. Callisto for the second, third, and fourth respondent. Well, I believe we've done the house. Everybody has supplied the necessary documents.
There was a decision we intended to supply.
Yes.
Unfortunately, I've been unable to print it for now, owing to the distance from our places to the office. But it's a decision, really, touching on the role of the DPP and all that.
It's okay. So how do we start?
I'll make reference to it, and then I'll make it available to the court and counsel. So our view is that we argue this application ourselves, two of us,
Yes.
myself and Mr. Wanjir. I'll take the body mainly.
It's okay.
The application, Mr. Wanjir has a small section. The
Yes.
application
Unless
to argue.
there's any other issues, we can begin.
Very well.
Yes. Proceed, Mr. Abuya.
Yes, for the applicants.
You need somewhere to rest your...
Absolutely. Now that our colleagues are taking statement, we have nowhere to.
Ishmael, will you manage?
Yes.
If you're not using the chair, you can pass it to Ismail.
No, you want to just stand.
Okay.
I have sufficient energy.
No, I have an issue with Ismail is on fast.
Yes.
So you don't want it to collapse.
This is better.
You can mute. There are people appearing a different court but addressing us. Okay, well, Mr. Abuya, you may proceed.
Yes. Your Honor, may I start by laying the foundation or the basis or the background of this application. then probably, Your Honor, you'd appreciate the issues that may be before you for determination. On the 18th of January, 2025, a young man, 31 years old, called Brian Odhiambo, while in the custody of KWS officers in Lake Nakuru National Park, mysteriously disappeared from their custody. I'm saying this deliberately, Your Honor, because there's no explanation to it. Mysteriously disappeared from their custody. And to date, he has not been found. His whereabouts are not known. His wife and his mother moved to the High Court for an application of habeas corpus. On the 6th of February 2025, the High Court, that is Justice Nangea, rendered a ruling to the effect that those who had been cited did not have the body or did not have Brian, so they could not possibly produce him. But the High Court further stated that it would not give any further directions on that issue and that the prosecution process continues. Because, Your Honor, for the record, there is an appeal that has been filed with respect to that ruling. We would wish not to get into it, otherwise we will fall for the matter being sub judice at that level. But, Your Honor, in a bid to get closure or an understanding as to where their kin is, they have again moved to this court because it is vested with the jurisdiction to carry out what we are asking it to carry out, a public inquiry that is pursuant to Section 385 of the Criminal Procedure Code. But this court has the jurisdiction to inquire into various issues, among them being that which is stated in Section 386(1), I believe that should be D, the circumstances surrounding the disappearance of an individual who may or may not be dead. You know, we filed this application and we came for directions before you, but we received responses. The theme that runs through the responses that we received from KWS, or DPP, and the Honorable Attorney General is no. A private individual cannot move the court. That's what they are saying. Private individual cannot move the court for purposes of carrying out an inquest. And possibly that would be the only question that Your Honor may be asked to determine whether a private person can move the court for purposes of carrying out an inquest. Our answer to that question, Your Honor, is that yes, any person can move the court to ask the court to carry out an inquest on the preliminary. Your Honor, it has been suggested in the affidavits that the basis for saying no, it's only the DPP that can inform the court. In fact, the word they use is direct the court. For a moment I shuddered because I wondered what happens to judicial independence anyway when the word is that someone can direct the court. But be that as it may, that's what they say, that it's only the DPP that can direct the court to carry out an inquest. And the basis for that is that Section 388 of the CPC, for the record, that section states that the DPP may, because that is the word that is used. Interesting that Your Honor, I have to use this word again, which has become common in this country, may. So they say the DPP may direct the court. Our colleagues forget that an inquest is a judicial function. It's a judicial function. That is number one. And number two, an inquest is an investigative role. So much so that the DPP will not be prosecuting anything pursuant to Article 157, but the DPP, like everyone else, would be informing the court of the need to conduct an inquest. The role is so peripheral, I wish to persuade the court to see it as such. It's so peripheral that even Section 3 should be 386 gives the role of informing even to a police officer. 386 also says an officer who becomes aware of all those that are listed there may also inform the court. Now we have a DPP who says it's only me who can inform the court, while 386 says even an officer can inform the court. But Your Honor, it doesn't even stop there. A reading of Article 22, 23 of the Constitution on enforcement of human rights. Now dealing with the question of locus standi, and the drafters of the Constitution being acutely aware of what the DPP is telling the court now, that it's only me who can inform, opened the window to everyone else who would want to approach the court for purposes of enforcement of a human right that is at risk of violation. So much so that then, here is Brian Odhiambo, who has disappeared. But here is a DPP who is strolling, perhaps waiting to be prompted, rather than he can swing into action. A responsible citizen in the name of Vocal Africa, and an aggrieved wife in the name of Alvia Oko have said, let us go to court, because the courts anyway would have the final say on these issues. And so, Your Honor, we are not asking the court to direct the DPP to carry an inquest, because anyway they are saying the DPP is beyond direction. And they'll tell you that is what Article 157.10 says, that they cannot be directed. We're asking the DPP to we're asking the court to take notice of the fact that Brian Odhiambo is lost or disappeared. And because the court has the jurisdiction to order for an inquest, direct that an inquest be carried into the disappearance of Brian Odhiambo. That order in no way directs the DPP to do anything. It's not a directive to the DPP. It's not a consent to the DPP. Your Honor, would also note that the wordings of Section 385 of the CPC use the operative word may, and this also goes to the discretion. I want to say this: the power to conduct a public inquiry is both mandatory and discretionary. So that even if Your Honor would receive a directive, quote unquote, from the DPP to get into an inquest, the law still allows you to say, no, I will not do that. And this is us invoking the discretionary power of the court, say, information has been brought to me, I find this information necessary, and therefore I order that there be an inquest. Your Honor, perhaps two issues, then I invite my colleague to say a word or two. Number one, from the court to note that there are only two institutions in this country that have been mandated to carry out investigations. The DPP is not one of those institutions. It is the Directorate of Criminal Investigations, that is the DCI, and now the courts pursuant to Section 385. Why DPP would be opposed to a court carrying out an investigation is preposterous, to say the least. Unless the DPP say, we are heavily invested in this, we don't want the court to carry out an inquest. Or for what other reason would the DPP be opposed to an inquest? The other thing I needed to let the court know is that in the affidavits they are saying an inquest cannot be carried out because we do not have a body. Now, that is, in my view, an outright misapprehension of the law, misapplication of the law. It will be for the court to determine, if the court allows our application to conduct an inquest, it will be for the court to determine whether Brian Odhiambo is dead or not. And the law would allow for presumption of debt if it will be necessary. You will also be told by the prosecution, Your Honor, that they are seriously, the DCI is seriously conducting an investigation. They are aware, and I'm aware, because, Your Honor, I have participated in this process for the longest time, that on Friday, should have been the 20th of February, Your Honor, just so that they may look like they are doing something really concerning this disappearance. The affidavit that was sworn by a colleague from the DPP had said they had received a file. They are not telling the court that they have returned that file because they felt the investigations done were shoddy, for lack of a better term. They have returned that file to the DCI. I'm glad my friend is here, because I was with him on Friday then when he had asked me to help him. He is the deputy DCI, Nakuru East. He's here. I don't know why he did not swear an affidavit or if he has sworn any. But I was with him. He has again asked me to bring him. I was actually to bring him another witness. That's what they are doing, trying to patch up things. What they are not saying, Your Honor, in so many words is that we are not doing any investigation. We are buying time. That's what they are saying. They are buying time. DPP have said the investigations that you have done and forwarded a file to us do not look like anything we can act upon. Now, our question has been all along. The court is better placed to really inspire public confidence now that this is a matter of public interest. Why can't the court be moved to carry out an inquest? DPP tell us we must write to them so that they can write to the court. I think that is the highest level of irresponsibility anyone would. They're saying we know Brian is missing, but write to us to tell us to write to the court to carry an inquest. Your Honor, on the basis of those grounds, while I invite my colleague to speak to the question addressed by KWS on whether this matter is res judicata or not, I'd wish to persuade the court to find that no reasons have been proffered, save for things to catch on, straws, weak ones, and that you allow our application and direct that there be a public inquiry into the forced disappearance and possibly murder of Brian Odhiambo. Your Honor, before my colleague takes his stand, may I also ask the court to refer to the decision. It's a petition, a High Court petition, that is Mwangi versus Director of Public Prosecutions and others. It's petition E118 2024. It's a June 14, 2024 decision. June 14, 2024 decision. Instructive paragraphs. Would be from paragraph 38 through 46 of that decision. Your Honor would note that in that petition, for clarity, DPP had argued that they would not be subject to directions by anyone on the carrying out of their functions. And the court, in those paragraphs, extensively discussed and indeed agreed that the DPP cannot be directed except that Article 157.11 has a rider. 157.11 has a rider to what is in 157.10, issues to do with public interest, and where we believe there is abuse of the legal process. But even so, even as the court would look at that, it's imperative to note that the power to conduct an inquest is not a function of the DPP, but it's a function of the court. And it's the DPP this time trying to guard the court from carrying out its judicially, let me say, to carry out its judicial function. May I rest and invite my colleague.
Yes, sir.
You know,
So, want to proceed?
apart from the grounds that have been submitted upon by my colleague, the application is opposed on grounds that the same is res judicata. You know, it is our humble application, it is our humble submission that the same is not res judicata. You know, the jurisdiction of the court for an habeas corpus application is vested in the High Court. That is under Article 26 of the Constitution. The jurisdiction of the court to hold an inquest is provided for under Section 385, 386, 387, and 388 of the Criminal Procedure Code. You know, in the application for habeas corpus before the High Court, the issue of an inquest was not deliberated upon or determined in habeas corpus proceedings. We submit that an application for habeas corpus seeks to compel the production of a missing person, whereas an inquest seeks to determine the circumstances surrounding the disappearance or the death of the subject matter. You know, the doctrine of res judicata has been elucidated upon by previous decisions of the court. I wish to refer the court to the court's decision in Abog James Odera versus John Patrick Machira. It's a civil application number 49 of 2001. I wish to equally refer the court to the decision of Lota versus Tanaki. It's a 203 East African 556. In both decisions, the court laid out the factors to consider with regard to establish whether a matter is res judicata. They include that the suit must have already been tried between the same parties.
Suit
Must have been tried between the same parties. Your Honor, in the previous habeas corpus application before the High Court, the parties were Elizabeth Auma and Independent Medical Unit as the petitioners, and the respondents were In Charge Lake Nakuru National Park and the DCI. In the instant suit, the parties before this court are Vocal Africa and Alvi Aoko Okelo as the applicant in the instant suit. And it's on that ground that we submit to this court that the suit is not between the same parties. The second issue the court considered in the authorities highlighted is that the claim must be based on the same cause. It is our submission that the habeas corpus application was based on the production of the body of Brian, while the instant application is based or seeks for a court to direct an inquiry into the circumstances leading to the disappearance of the subject matter. The other issue is that the issues must be identical in both suits, and as I've earlier submitted, the issues are not identical. Then the last factor is that the court which decided the former suit must have been competent to try the subsequent suit.
the previous.
The subsequent suit.
You said the previous, the court that tried.
The court which decided the former suit
Yes.
must have been competent to try the subsequent suit. We humbly submit that only the High Court has jurisdiction, and it is the competent court to hear and determine an habeas corpus application. While the magistracy is vested with the jurisdiction on inquiry on the circumstances. We humbly submit Your Honor, that on that ground, our application be allowed, as it's in the circumstances not res judicata in any way.
Your Honor, perhaps at the very close end, and to assist the court and our colleagues to understand that an inquest is not a function of the DPP, that it is a judicial function. We also cite the authority of Re Macau Musau. It's in Quest 1 of 2022.
Macau Musau.
Re Macau Musau.
Quest.
In Quest 1 of 2022. 2024 KEMC 25 KLR. It's a 3rd June 2024 decision. In that decision, Your Honor, in instructive paragraphs would be paragraph 10, 11, and 12 of that decision. Further, Your Honor, the other decision that may be of great assistance to the court and our colleagues is Waweru versus Republic. Criminal Revision E187 of 2023. KEHC 2410 KLR Your Honor, it's a March 6th, 2024 decision. Instructive paragraphs paragraph 20, 23, 24, and 25. We'll make these decisions available, Your Honor. At that point, we rest the applicant's case.
In our response, we oppose the application dated 14 February 2025, and that the applicants are seeking for an order or an inquest to be conducted. And Your Honor, we are not opposed that an inquest is a judicial function. What we are saying is that there is a procedure on how this inquest should be conducted. And this procedure is set out under section 3881 of the CPC.
3881.
Yes, of the CPC. And that this section states that the DPP may at any time direct a magistrate to hold an inquiry in accordance with section 387 into the cause of a particular death, to which the provisions of the section apply, and it shall, in this case, the innocent person believed to be dead, give such directions as it deems fit. Your Honor, the applicants have stressed the word may. We submit that the use of the word may is discretionary in the sense that upon the office of the DPP perusing an investigation file, order for an inquest to clarify or shed light into an investigation with the view to decide whether a charge is preferred or not.
Whether?
A charge can be preferred or not. Your Honor, as elaborated by that section 388(1) of the CPC, it clearly lays down the procedures which should be followed, and we rely in the case of Rimata of Pius Mukono Murage. Rimata of Pius Mukono Murage, 2019. Pius Mukono Murage.
Mukono.
Yes, Mukono Murage.
Yes.
2019 EKLR. My Lord, in that matter, Your Honor, in that matter, the court emphasized that where the statutes prescribes a specific procedure for redressing a particular grievance, same to be followed. And this position was also emphasized in the case of Masood Salim and another, versus DPP and 3 others. In this application, Your Honor, the applicants have not adhered to those provisions of section 3881 of the CPC. As from that section, it is clearly that it is the DPP who is to initiate the inquest upon writing such in a request to a magistrate. Upon writing a request for an inquest to a magistrate. You know, there is no statutory provision that has expressly provided that a private person has the mandate of that similar to the DPP of initiating an inquest. What the applicants have indicated, Your Honor, is that this inquest is a judicial function, which we are not disputing. It is a judicial function. But the question is, how is this inquest to be initiated in court? And that is what we are saying, it's only the DPP who can carry out that initiation under the provisions of Article 157 of the Constitution and Section 388 of the Criminal Procedure Code. To emphasize on that, Your Honor, we rely in the case of petition number 160 of 2012, the case of Francis Anyango Juma.
Francis?
Anyango Juma versus the DPP and the Commissioner of Police. Emphasize on paragraph 26 to 29. In that referred petition, the court was also faced with a similar circumstance where a private person had sought an order for an inquest. And the court dismissed that application, stating that it is only the DPP who can initiate an inquest. Your Honor, the applicants have admitted that the investigations are ongoing, and in fact visited the offices of the DCI. And allegations that these investigations they are buying time Your Honor, we submit that these allegations are baseless. As investigation is always a continuous process, and all areas of investigations need to be covered and cogent evidence need to be established before a decision to charge is made. You know, we submit that this application at this stage is premature. Directing an inquest will preempt the outcome of the investigations, which are at a very active stage.
Will preempt
the outcome of investigations which are at a very active stage. And the mandate of the first respondent is to direct investigations as to the DCI, who is the third respondent, to conduct investigations. We are urging this court to allow each state organ to conduct its mandate as stipulated by the Constitution, by dismissing this application. Your Honor, the respondents have also stated Article 22 of the Constitution.
The respondents?
The applicants, sorry, have stated Article 22 of the Constitution, which allows private persons to move the court in respect of enforcement of human rights. We submit that nothing has been brought forth before this court indicating that the respondent, specifically the first respondent, has violated any constitutional right against the applicants. This is so because the investigations are ongoing and the third respondents were directed accordingly as required by our mandate to conduct investigations with those few remarks. We are praying that this application be dismissed as it lacks merit.
Respondents?
Yes. For the first respondents, that will be all.
So we have Mr. Rotich and Mr. Callisto. Who is going?
Yes, Mr. Rotich.
Yes, Mr. Rotich.
On our part, we shall be relying fully on the submissions of the first respondent. Yes, Your Honor, on behalf of the second, third, and fourth respondents,
Yes.
we file through replying affidavits. One is dated 25th February 2025. And the second one is dated, yes, both are dated 25th February, the two replying affidavits. And maybe, Your Honor, on the issue of res judicata, which was raised in our affidavit, the same was in relation to order number 3 in the notice of motion application. And it is our submission that the same also came up in the habeas corpus application. In which the High Court, in its ruling, ruled that the prosecution process that was underway takes its course. We have attached a copy of the ruling to our replying affidavit. Also, Your Honor, I have had a counsel for the applicant submit that they have appealed the said ruling. That means they have appealed to the Court of Appeal. And as we speak right now, Your Honor, we have two concurrent proceedings in relation to this matter. And we submit, Your Honor, that one should take precedence. Also, we asked you, Your Honor, as submitted by my colleague, Counsel for the first respondents, to exercise the doctrine of constitutional avoidance.
Pardon?
To exercise the doctrine of constitutional avoidance, where it provides that courts should not interfere, but let other constitutional bodies perform their functions. Also, Your Honor, there are some allegations that have been raised in the further affidavit, more so against the Director of Criminal Investigation, and which some we take offense of, mostly paragraph 20 of the further affidavit.
Further affidavit.
Yes, yes.
Sworn by who?
Done by somebody who sent a lead. These are
Sworn and lifted, so that at least we don't confuse being a further affidavit.
4th March 2025.
Yes, proceed.
Yes, it's to the effect that it said that asking DCI to investigate our colleagues at KWS is akin to asking a monkey to determine a matter of the forest. The DCI have also been accused of attempts to cover up their colleagues at KWS. Your Honor, these are allegations which have not been substantiated. Your Honor, the DCI have carried out their mandate, and in our affidavit, Your Honor,
People making noise outside there. Probably they should be told to tone down. Yes, proceed, Mr. Rotich.
yes, I was saying the DCI have carried out their mandate, and in our affidavit, we have attached a forwarding letter dated 28 January 2025. The same was forwarding the investigation file to the first respondent, showing the investigation carried out by the third respondent. So these are allegations which are unsubstantiated. In conclusion, Your Honor, we feel that this application is premature and the same should be dismissed. That's all, Your Honor.
Sir, responding.
Your Honor, in rebuttal, I wish to start from where Rotich has left. I think either counsel, with a lot of respect to my colleague, did not listen to the submissions by my colleague here on the issue of res judicata and even on the appeal. For clarity, what was before the High Court and what was at the Court of Appeal was an application for habeas corpus. What is before you is an application asking you to direct an inquest. Your Honor, if we cannot even differentiate habeas corpus from inquest, becomes a problem. The least we say about that submission, the better for counsel and the court. Our view is that it's not merited. It's an off submission, really off. What counsel Rotich is also not telling the court is that DPP has since returned the file to the DCI. think he must be guilty of material non-disclosure to the court. If he says that they have concluded the investigations and forwarded to DPP, and DPP has returned it to the file back to the DCI and say there are no investigations here, do better. And really, that letter of the 28th, in my view, in our view, holds no substance really. Must be seen for what it is, gaslighting. Actually gaslighting the applicants. A decision was placed before you by our colleagues. That was Francis Anyango Juma versus the DPP and the Commissioner of Police. To submit that decision is distinguishable. We are going to do exactly that. What was before that court? Your Honor would also note that possibly they had applied before the wrong court, number one. They were asking the High Court to order an inquest, carry out one. It definitely did not have jurisdiction. Number two, at decision, at paragraph 26, now at paragraph 23 of that decision, to be precise, what the applicant in that matter was asking the court, and the court correctly captured, and I'll read verbatim, all that the petition accuses the respondents of his failing to investigate the circumstances surrounding the death of the deceased. However, the averments by the petitioner with regard to the alleged failure by the respondents have been controverted. That's number one, the supporting documents. And further, the cause of death in this decision, the cause of death of the deceased in this matter was known. It was a road traffic accident. What we have before you is a disappearance. What we have before you is a disappearance. Someone got lost into thin air. And they're asking the court to be persuaded that those two matters are relatable, where one, for one, the cause of death is known, and where for the other, someone has just disappeared. We're asking the court to investigate. You have been asked also, Your Honor, to invoke the doctrine of constitutional avoidance. What counsel who submitted didn't tell you is what constitutional process is ongoing, so that you let it take its course. Just saying, we are a constitutional body mandated to take that in a particular function, so court avoid. But they are not telling you what constitutional mandate they are undertaking, which is actually, in real sense, shrouded in secrecy. It has also been alleged that we are buying time. Now, sorry, it's been alleged that Article 22 does not apply. and that we have to demonstrate what Ham Voko Africa and Alvia Oko, in terms of their rights, have suffered, so that then they can move the court. Unfortunate that we are making such submissions in 2025. Perhaps those were submissions that would have been made to the court pre-2010. Issues of local standing are well settled. Well settled. Your Honor, it has also been submitted that there is an express procedure there is an express procedure. What the DPP didn't do was point us to that procedure. But even so, the applicants would have a recourse in the provision of Article 159. That justice would be served with undue regard to procedural technicalities. In fact, the technicality here that the DPP would wish to rely on is them writing. Not that anybody has insulted them or done anything, or that they were going to do something so major. They are saying it is for us to write to the court, it's not for you. Your Honor would find that in Article 159 1D, the Constitution. Your Honor would also note that the applicants are acting in public interest, and that this is a matter of immense public interest, and that if the respondents would have appreciated the interest therein, then possibly what their proposal would have been was, anyway, we are writing to the court, like we should, to carry out an inquest. But what are they saying? You can't write to the court, you have to wait for us to act. Anyway, stonewalling access to justice. Article 10. And the values would at least guided the Honorable Attorney General and DPP in this regard. National values. Our view is that the submissions that have been placed before you, Your Honor, have no regard the sanctity of life, human rights, all that. But finally, we have been accused of not tabling any evidence on anything, but we equally have no evidence placed before you showing that there are any investigations further, for that matter, that are being carried out. So it remains their word, which they believe should be taken as the law. We urge that the court does not send Ivy Aoko. She's here in court. We pray that the court does not send her away, her family, from the seat of justice. Noting the decision that we cited, that an inquest would also settle public unrest and all that. saying this court has an opportunity to set to rest. Not to sound as though I was blackmailing the court, but the court has an opportunity to put this matter to rest. And for a fact, Your Honor, an inquest would not even be prejudicial to anyone. I didn't hear anybody say they will be prejudiced. The respondents would not suffer any prejudice if the court were to take up this matter, conduct an inquest. If for some reason they don't want. Perhaps that is the unspoken word, the reason that they wouldn't want an inquest to be conducted. Your Honor, even as you listen to us, also listen to the unspoken. There is what is not being said. I'd urge you to listen to it too, as you render your ruling in this matter. And rest.
That's all.
Yes, Your Honor.
Yes.
We can take a date for ruling. That application.
There is we can come back on the 13th.
Of this month.
Yes.
And we can take the 13th. That should be a Friday or on a Thursday.
So 13th, let's try 13th of March.
The most of them.
Maswali ya kuuliza.